I am thrilled to bring together my good friends and colleagues today to talk about the Supreme Court. Professors Wojcik, Professor Acevedo, Professor McMurtry-Chubb, Professor Mundy, and Professor Ricardo will each say a few words about some selected cases. I'll say a couple of words about the court's term coming up and the court's shadow docket in the previous term. And then we'll try to reserve some time for questions and answers, as much as 20 or 30 minutes, I hope. I'll facilitate that. If you have questions along the way, please drop them in chat and we'll come around to them as we are able. I just want to say a very quick introduction here to the previous United States Supreme Court term. This was an extraordinary term for a lot of reasons. The court changed dramatically with the addition of Justice Amy Coney Barrett, who replaced Justice Ginsburg on the court. And we've seen that in the rulings that we're going to hear our friends and colleagues talk about today. This really is a turning point for the Supreme Court, and I think we're going to see it change even more next term. So fasten your seatbelts, hold on. We've got a wild ride coming. We're going to start to hear about that from Professor Wojcik. Now, instead of spending time giving lengthy biographies of our distinguished speakers, what I will do well, I thought I would do this. If I can figure out how to access the chat, I will drop their bio into the chat for you as they're speaking. With that, I'm thrilled to turn it over to Professor Wojcik.
Thank you, Steve. Thank you, Dean Spanbauer. We just want to remind everyone, why are we doing this? Why are we doing this now? Because it's coming up on the first Monday in October. That's the traditional start of the Supreme Court term, when the Supreme Court begins its new round of arguments. And we, as a faculty, for many, many, many years, have done a review and preview of the leading cases from the previous term and what's to watch for the upcoming term. So Fulton versus Philadelphia is my case from last term. Decided in June of 2021. It's one of these gay rights cases. Now, we've seen a lot of landmark cases from the Supreme Court in past years. Romer versus Evans, which overturned Bowers versus Hardwick. Obergefell, which legalized same-sex marriage. And last year's decision in Bostock, which made it extended sex to sexual orientation and gender identity, meaning you can't fire someone because they're LGBT. Those are the blockbuster landmark cases. Fulton is not one of those cases. This is a more along the lines of Masterpiece Cake, where that was a baker who who protested making a cake for a same-sex wedding, and he was charged, and the court found that there was problems in the hearing, and because of discrimination in the hearing, he didn't get a fair hearing, so the court ruled in favor of the baker for that case. That was one where we lost the battle but won the war. In the terms of the Supreme Court said, as long as the hearings are fair, it's fair game to apply the non-discrimination laws to public services. So Fulton is like that as well. Catholic Social Services is one of the agencies that the city of Philadelphia used to certify families for placement for adoption for foster children. And the city of Philadelphia had a non-discrimination ordinance, and it required its city contractors to affirm that they would not discriminate on the basis of sexual orientation. So Catholic Social Services, one of the agencies that would certify families, refused to do that. They said, we're not going to say whether or not we'll certify same-sex families. And they challenged that in court under the First Amendment for free exercise and free religion clause. And the decision was 9-0. So that should tell you something about it. It's not a split decision, it's 9-0. That what the problem was is that the contracts that the city used had this waiver provision that could be used by a single commissioner. A single commissioner could decide whether or not to waive the prohibition on sexual orientation discrimination. Because there was this discretion in a certain individual without any standards for it, the Supreme Court said, no, that's not a good law. It's not a good contract. So what happened is that Catholic Social Services won. It was reported as a victory for for Catholic adoption agencies. But what the ruling says is you can't have a waiver that's just exercisable by one person with no discretion. They can do it with what they want with it, but it's not really an important decision for that reason. It is an important one for affirming that had that not been in there, then it would have applied. So Catholic Social Services would have had to apply if that waiver had not been in there. What does it mean for the city of Philadelphia? They have to rewrite their contracts. And if a case goes up again, Catholic Social Services will lose. What's coming up in the next term? I also teach international litigation classes. And there's a case called Servotronics versus Rolls-Royce. It's going to be heard on October 5th, so Tuesday, the first day after the first day. And it involves international discovery. There's a statute, a federal statute called 1782, 28 USC 1782, that allows an interested person or a foreign court to apply to a US district court to obtain evidence in the district where the district court is located for use before an international or foreign tribunal. There's different ways of getting discovery. Letters rogatory, the Hague Service Convention, the Hague Evidence Convention. But this statute, the 1782, was intended to facilitate discovery for use in foreign courts and foreign tribunals. Good enough. What's the issue here is that there's a dispute about whether foreign tribunals includes arbitration tribunals. Normally, you don't have any right to seek discovery for an arbitration tribunal at all. You maybe might exchange a contract or two, a document or two, but there's no right of discovery in arbitration. So people have been using 1782 to get around that reality. And we're going to see now a resolved split in the circuits between the courts that say, no, it's just for tribunals, or it's also for arbitration tribunals. I have no idea how they're going to go on this. It's an interesting one. It's coming up from the 7th Circuit, but Servotronics versus Rolls-Royce will be heard on October 5th. Thank you, Steve.
Oh my goodness, I forgot to unmute myself. I'm sorry. Professor Wojcik, outstanding presentation. Thank you very much. The Catholic Social Services case is a really interesting case. There are a lot of moving pieces in that case, and many expected the Supreme Court to take a sharp turn on the religion clause. We'll see if it is to do that in future cases. Thank you again, Professor Wojcik. Next up, we have Professor Acevedo. Professor Acevedo, take it away.
Thank you, Professor Schwinn, and thank you very much for organizing this presentation. And I also want to thank my colleagues who are also stepping up and sharing their thoughts about Supreme Court cases. I'm going to be talking briefly, and I say briefly because these are long opinions, about the Brinovic versus DNC case, which is a voting rights case, and then California versus Texas, which is another bite at the apple for to try to eliminate the Affordable Care Act. So let me share my screen. I've got a couple very simple slides here. Here we go. Hold on. Okay, can everyone see that? All right.
Yes.
So I thought it would be interesting to begin with Justice Kagan's dissent here, because I think it helps to frame what this dispute is about. And this language comes from her dissent, and she says democratic ideals in America got off to a glorious start. Democratic practice, not so much. The Declaration of Independence made an awe-inspiring promise to institute a government deriving its just powers from the consent of the governed. And these are principles that we keep talking about in our classes about the legitimacy of legislation. And she goes on to say, but for most of the nation's first century, that pledge ran to white men only. The earliest state election laws excluded from the franchise African Americans, Native Americans, women, and those without property. And I think it's important for us to really understand the tension that is obvious in this case, because Justice Kagan and the dissent view this very much as a race-based initiative by the state versus how the majority views this. They view it drastically differently. And I think it's interesting for us to understand this. Let's see. So what I have up here on the screen is a timeline that I think is missing from a lot of our casebooks, because what our casebooks do an excellent job is that they talk about the founding of the Constitution, which is back in 1788, but they really do not address in sufficient detail the benefit of the Reconstruction Amendments. And so we see here on the timeline, 1865, the 13th Amendment was adopted, 1868, the 14th Amendment, and 1870, which is at issue in our case here, is critical with the 15th Amendment. Then we move forward on the timeline, and I just selected certain statutes and cases that are relevant to this Brenovich case. In 1964, to put the Civil Rights Voting Act in context, we need to understand the Civil Rights Act of 1964, which was passed to further the civil rights of individuals in our country. Then the following year, Congress enacted the Voting Rights Act of 1965. And I'm going to talk a little bit about Section 2, which is specific in this case, and just touch upon Section 5. And then on the timeline, we can see that in 2013, Shelby County was decided and curtailed the rights under Section 5. And then Brenovich is the case that we are going to be discussing here. So context is important when evaluating voting rights litigation. The issue of voting itself has a long and challenging history in our country, and the US Constitution itself does not indicate how voting is to be conducted. When the Constitution was ratified in 1788, it did not include an express protection of the right to vote, and it was left to the states to determine who was eligible to vote in our elections. For the most part, state legislators generally limited voting to white males who owned land. Some states also utilize religious tests to ensure that only Christian men can vote. And gradually over time, we saw a change in the state legislatures and their attitude, and they began to expand voting rights to non-land owning white males. So then we need to keep two things in perspective. One is the fact that this case deals with Section 2 of the Voting Rights Act. And Section 2 has a general provision barring discrimination against minorities in state and federal election. And this case here, here I have Section 2 of the federal statute, which talks about no qualification or prerequisite to voting or standard practice shall be imposed or applied by any state on account of race or color. And this is the federal statute that protects the voting rights of individuals. And this case deals with two of Arizona's election policies, one which outlaws ballot harvesting, as it's known colloquially in the media, and another with banning out-of-precinct voting. And what ended up happening was that the DNC filed a lawsuit challenging Arizona's voting laws. And the DNC argued that rejecting ballots cast in the wrong precinct violated the First and the 14th Amendments, and that the state statute HB 2023 violated the 15th Amendment and Section 2 of the Voting Rights Act, and that the legislation discriminated against Hispanics, African Americans, and Native Americans. As we see here on the screen, the Voting Rights Act is one of the most significant pieces of legislation to protect voter rights for minorities by preventing state and local governments from racial discrimination in their state election laws. And the voting rights operated as intended by Congress for almost 50 years. However, two recent decisions dealt a near fatal blow to the continuing vitality of the Voting Rights Act. So in 1963, just by way of background, the Supreme Court decided the case of Shelby versus Holder. And in Shelby County, the Supreme Court effectively eliminated the Voting Rights Act Section 5 pre-clearance requirement. And what did this pre-clearance requirement do? It mandated that state and local governments in 15 states seek permission from the federal court or the Justice Department before making any significant changes to their local voting laws. The reason being because there was this history of discrimination in these particular jurisdictions. Well, the majority in Shelby County held that this coverage formula, which was last amended by Congress in 1975, was unconstitutional in light of current conditions. And because it was based on old data and therefore outdated practices. The effect of Shelby County is that by eliminating the pre-clearance requirements, it now makes it possible for state and local governments to freely pass these, quote, facially neutral voting laws that impose burdens on voters and that have a discriminatory impact on minorities, which is what the DNC is alleging. Since Shelby County, a number of states have passed hundreds of facially neutral voting laws under the guise of voting integrity, albeit without one iota of evidence of massive voter fraud in any of these states. For example, we have state initiatives that include limiting hours, limiting access to mail-in ballots, prohibiting the distribution of water and food to voters, requiring stricter identification checks, and limiting drop-off boxes to centralized location. If anyone's interested in learning more about this, there is this great website called Voting Rights Lab. You can go there and click on it and learn for yourself all of the different restrictions that are being enacted at the state level. Enter our current case, Brnovich versus DNC. And Brnovich involves a challenge under Section 2 of the Voting Rights Act of 1965. And what is it that Arizona did? Specifically, Arizonans who vote in person on election day in a county that uses the precinct system must vote in the precinct in which they are assigned based on their address. And if a voter votes in the wrong district, their vote is not counted. The second significant thing that Arizona did was that for Arizonans who vote early by mail, Arizona House Bill 2023 makes it a crime for any person other than a postal worker, an election official, or voter caregiver, family, or household member to knowingly collect an early ballot, either before or after it has been completed. Well, the case comes before the Supreme Court, and the Supreme Court held by a 6-3 decision that neither the out-of-precinct policy nor HB 2023, which prohibits transporting the ballot, are unconstitutional. It also finds that the state statute, HB 2023, had been passed and that there was no intent of racial discrimination. Alito's opinion acknowledges that Congress enacted the landmark Voting Rights Act of 1965, and that it took the government roughly 95 years to operationalize this statute after the passage of the 15th Amendment. And that Alito also recognizes that despite the ratification of the 15th Amendment, the right of African Americans to vote was heavily suppressed for nearly a century. And you can go into the opinion yourself, and Alito references how states employed a variety of notorious methods, including poll taxes, literacy tests, property qualifications, white primaries, and grandfather clauses. And these are all challenges that the court went on to examine. However, the majority would go on to conclude that there was no evidence that, in this case, that the state legislature was imbued with racial motives or racial animus with respect to passing these particular provisions. And instead, Alito cites to a statement made by a Democratic state senator who remarked that the state law is aimed to solve the fact that one party is better at collecting ballots than the other party. And in its analysis, the court offers these guideposts to analyzing future conflicts with respect to voting rights litigation under Section 2. And again, you can read the opinion to get a better feel for what these guideposts are. As I pointed out in here, Justice Kagan issued a 41-page dissenting opinion. And this is where it gets interesting when you read both the majority and the dissenting opinion, how they can both analyze the conflict and they both arrive at a different conclusion with the same set of facts. And Justice Kagan talks about how this court has no right to remake Section 2 of the Voting Rights Act. Maybe some think that vote suppression is a relic of history And so the need for a potent Section 2 has come and gone. But Congress gets to make the call. Again, we have a very sharp difference of opinion. I would recommend to everyone here to read the opinion and the dissent. It's an outstanding and an interesting opinion. Let me move on to the next case, California versus Texas. And what I now have in front of you are the constitutional standing requirements that the courts look to determine whether a plaintiff has a case or controversy. And this is exactly what this case is about. This case is about a standing issue. This is, as I mentioned earlier, this is another bite at the Affordable Care Act. And the Republican Party made it one of their top priorities to do away with the Affordable Care Act. So what happened in our case here? California is a case that dealt with the constitutionality of this Affordable Care Act. And as we know that in some circles, the Affordable Care Act is known as the Obamacare. And the ACA requires individuals to obtain medical coverage known as the individual mandate. And individuals who fail to obtain insurance coverage are subject to a penalty. So in the earlier case of National Federation of Independent Business versus Sebelius, which was decided by the Supreme Court in 2012, the court ruled by a 5-4 majority that the individual mandate was constitutional, and it was a constitutional exercise of Congress's power under the tax and spending clause of the Constitution. One of the issues in the rationale in the Sebelius case was whether a penalty is a tax, and that was central to that case. And at that point in time, in 2012, when this case was litigated, there was a very real possibility of a financial penalty for individuals who did not have insurance coverage. Well, the Supreme Court ruled in the Sebelius case that the question is not whether that is the most natural interpretation of the mandate, meaning whether a penalty is a tax, but whether it is fairly possible. And this interpretation really set off a firestorm about how the Supreme Court was being activist and rewriting federal legislation. The current controversy in California versus Texas takes this step one further. The present controversy deals with whether a zero tax, an effective rate of zero, renders the statute unconstitutional. Congress had changed the penalty rate to zero with the passage of the Tax Cuts and Jobs Act in 2017. So when this case comes to the Supreme Court ruled 7-2 that this is a standing issue. And so let's see, it looks at the claims made by the individuals. The individuals are here, there are two sets. There's claims made by individuals and then claims made by a group of states. And the individuals claim that they suffered a particularized harm in the form of the payments that they have to make and will have to make each and every month to comply with the federal requirement. So they are claiming a harm in the form of these payments. And the court response was, well, how can there be a harm if there is a zero penalty plus no enforceable government action, meaning that the government itself was not going to be enforcing the action? And without a government enforced action, with the penalty being zeroed out, the IRS can no longer seek a penalty for those who fail to comply, and therefore there is no traceability to government action. So if we go back to this constitutional standing requirement, what the courts look to is that they look to these three requirements. There must be an injury to the plaintiff, traceability to the conduct of the defendant, the government in this case, and redressability by the courts. So the claims by the individual state challengers, those claims fail. Well, the court then looks to the claims by the state plaintiffs. And there are two principal claims being made by the states. The states are claiming that they have an indirect injury in the form of an increased cost because of the state-operated and state-mandated insurance program. And the court response here was that without any prospect of a penalty, again, the states have failed to prove their particular injury and therefore traceability to government action. And then the second state argument is that the states incur additional costs by providing beneficiaries with certain information in terms of healthcare coverage and by providing the IRS with related information. And the court response here was pretty clever. It said that there are other provisions of federal law that require these particular informational requirements, and therefore this is not relevant to their particular state claim. So in the end, the majority finds that this is really a standing issue and rules on that basis. In dissent, Justice Alito, who's joined by Justice Gorsuch, issued a 32-page dissent, and Alito writes that no one can fail to be impressed by the lengths to which this court has been willing to go to defend the ACA against all threats. And he says plainly, a penalty is a tax. The United States is a state, and the 18 states who bear costly burdens under the ACA cannot even get a foot in the door to raise a constitutional challenge. So needless to say, again, we have this difference of opinion in the terms of interpretation and application of this particular statute. I will stop here so that we can continue forward in the program. Thank you, and thank you, Professor Schwinn, once again for putting this together.
Professor Acevedo, that was outstanding. Thank you so much. What a wonderful presentation. And I'm so glad that you talked about the history and context of both of those cases, so critical to understanding what's going on in those cases. And I would urge and invite all of our participants to take a look at those rulings, the Brnovich ruling and the Texas versus California ruling on the Affordable Care Act. They're just so important. And Professor Acevedo, what a wonderful job putting them into context for us. Thank you. Before I introduce Professor McMurtry-Chubb, I just want to make an announcement to all the participants. We unfortunately don't have access to the chat function today, so I won't be able to put a link to our speakers' bios and other information in the chat function. I apologize about that. And you unfortunately won't be able to ask questions through chat. So when we come to Q&A, we'll just do a hand raise as we do oftentimes in Zoom classes without the chat function. And again, I apologize for that, but I think we can work around it. Next up, our very own Professor McMurtry-Chubb, who will talk about some very recent activity at the Supreme Court. Professor McMurtry-Chubb, take it away.
All right. Hello, everyone. So what I want to talk about is, I've titled my presentation, The Path to Whole Women's Health v. Jackson, which is the Texas abortion case, which was decided during the court's shadow docket. And so I wanted to, my presentation is framed in terms of lessons from Anita Hill, but more generally, I want to talk about this kind of growing fiction, which is concerning to me, about the court being a non-political body. It has, from its inception, and continues to be political. And this is kind of damaging, and also getting to the heart of why these women, starting with Anita Hill and Christina Blasey Ford in our most recent memory, wanted to bring to our attention the character flaws and the missteps of those who would be on the Supreme Court and why that's important. So here's a picture of Anita Hill and Christine Blasey Ford. As you know, or may not know, Anita Hill raised allegations of sexual harassment against Clarence Thomas, and then Christine Blasey Ford does the same with respect to Justice Kavanaugh, right? And that's her giving her, Christine Blasey Ford is on the left, raising her hand, giving her testimony to the Senate Judiciary Committee. And there are Anita Hill and Christine Blasey Ford together. And so women know, right, that if you are, this is a person who has going to have a lifetime appointment on the court, and does not necessarily respect women. And so you would think it would be a logical conclusion to say, well, when there are issues that come up that involve women, these two gentlemen might not be so respectful of women's rights. It might seem like something that's logical. It's not, because people say, well, they're judges. They're neutral. Of course, they're going to uphold the law. How they feel about women or not going to matter. Fast forward that there was a lot of activism around Justice Kavanaugh's appointment, the same as there was activism around Clarence Thomas's appointment. And most of that activism came from women, women who were on the streets marching against Kavanaugh in support of Christine Blasey Ford. I put on this slide, kind of a tongue-in-cheek, you too? Yes, us too. That 900 women law school faculty professors signed a letter opposing Justice Kavanaugh. And then there was another letter of law professors that was signed with over 2,400 signatures. They included the 900 from the women law professor letter. Why was there a split? So there was this kind of, again, there was this organic movement among women law professors. And we said, you know what? It's important that we speak as one voice against the confirmation of Justice Kavanaugh. And so I was on the principal drafting team for the letter opposing Kavanaugh that was signed by the over 900 women law professors in the country. This was a really huge deal. We had a publicist who helped us with the letter. And also basically told us, listen, we are walking this letter. We had people walk the letter into the confirmation hearings so that it could be entered into the congressional record. So the women's law professor letter is entered into the congressional record. And our publicist told us that we were going to get death threats. So many of us on the drafting team, because our names, we didn't want the names of the women who signed the letter to be first. So we put our names first. And so many of us on the drafting team received death threats, et cetera, et cetera. So this was a really fraught process, but we believed in having this voice and speaking against Kavanaugh, because we knew that we were on this forward progression to overturn Roe, and that this was the beginning of the end, right? But we know what happened. He's on the court. One other thing I want to mention is that the reason for the difference in the two letters is because the women law professor letter, we only wanted it to be signed by women. And so there were some men who took issue with that and who then started their own letter. That's another conversation that is related, but I will move on. So patriarchy's predictable response is the devil in the shape of a woman, right? Amy Coney Barrett, who she comes wrapped in, it's a woman on the Supreme Court. You all should be happy. But Amy Coney Barrett, again, has a record of, she made no bones about it that, she was going that, her politics, and she made no bones about it, that Roe was in her sights to take down. But again, advancing this fiction that, I had these beliefs. I'm a member of the People of Praise, which is an ultra-conservative group inside the Catholic Church. And we believe in all kinds of things, not the least of which is we believe in the life of an unborn fetus over the women's right to choose, but has in the press during her confirmation said, that is separate from my ability to make judicial decisions. Again, this fiction of what you believe deeply in your heart is somehow separate from your ability to uphold the law. Okay, so these are the cast of characters. Next, we've got the bill at issue. So the Texas law starts here. Senate Bill 8, relating to abortion, including abortions after detection of an unborn child's heartbeat, authorizing a private civil right of action. This is also known as the Texas Heartbeat Act, and it's enacted in May of 2021. This timeline is stunning, you're gonna see. So I excerpted some of the language from the bill so you can see it. I'm a historian, and I always go back to the primary sources. And so I pulled every single source that I could find. Even, I will do a deep dive later on for my own benefit to look at, what was the debate on the floor, what people were saying. But for our purposes here, I just wanted you to see this language that the legislature finds that the state of Texas never repealed, either expressly or by implication, the state statutes enacted before the ruling in Roe v. Wade that prohibit and criminalize abortion unless the mother's life is in danger. Wow. Like, what a stunning pronouncement by the Texas legislature, right? So they're bold. They're not hiding the purpose of this act, right? Although you will see that the language is kind of couched in women's health language, when in actuality, it's the opposite. And you'll see a lot of this. Professor Acevedo talked about voting acts. I urge you to go to the voting lab so you can kind of see the language that legislatures are employing to make it seem like they're trying to uphold voting rights, but actuality, they're undermining it. Same thing here. More language from this Texas Heartbeat Act. You'll see the legislature finds, according to contemporary medical research, so they're focusing on the heartbeat of fetal heartbeat, cardiac activity. And see here, sections 3 and 4, Texas has compelling interest from the outset of a woman's pregnancy in protecting the health of the woman and the life of the unborn child, and to make an informed choice about whether to continue her pregnancy. The pregnant woman has a compelling interest in knowing the likelihood of her unborn child surviving to full-term birth based on the presence of cardiac activity. So it makes it seem like we're here to protect women. The determination of the fetal heartbeat, standard medical practice includes employing the appropriate means of detecting heartbeat based on estimated gestational age. You have doctors who have been speaking out against this particular section and saying that what passes as fetal heartbeat is this sometimes electrical activity that is in the body, right? So, again, the legislature is not necessarily adhering to the best practices of science here. And then we have the money shot here, which is the civil liability for violation or aiding or abetting the violation. So by statute, the enforcement of the law goes to private citizens. And this is the issue here, that anybody can bring a lawsuit against a doctor who is performing an abortion in violation of this act. So now we have the complaint, Whole Woman's Health v. Jackson. July of 2021 is when this complaint is filed. So remember, this Heartbeat Act enacted in May, lawsuits filed in July. And again, the first paragraph of the complaint, I love this. The Texas legislature's well-documented hostility to the rights of pregnant people has gone to a new extreme. The lawsuit is brought under 42 UIC 1983 to challenge Texas Senate Bill 8, which flagrantly violates the constitutional rights of Texans seeking abortion and upends the rule of law in service of an anti-abortion agenda. If this attempt to strip Texans of their federal constitutional rights is not blocked, then any state could similarly subvert the federal constitutional rights of a group disfavored in that state. For this and many other reasons, SB 8 must be declared unconstitutional and enjoined. So Whole Woman's Health et al. Brings a complaint, and they want a preliminary injunction, right? They're bringing a complaint for injunction and declaratory relief. And so this is what is before the court. It's important that we understand this. This is procedural, right? And what the court says is, this is pretty unique procedurally, that a state legislature would put the enforcement function for the law on private citizens. So the person who would enjoin someone from acting would be a federal judge, right? And so in order to prevail on a motion for a preliminary injunction and declaratory relief, you have to show that you have a strong likelihood of prevailing on the merits. The court says that's not happening. And you also have to show irreparable harm. But again, showing irreparable harm is really difficult when the group of people who are bringing the injunction may or may not actually come before a judge who can then be enjoined from enforcement. So you see, this is like a really unique procedural conundrum. Justice Sotomayor, in her dissent, says the court's order is stunning, presented with an application to enjoin a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, a majority of justices has opted to bury their heads in the sand. Last night, the court silently acquiesced in the state's enactment of a law that flouts nearly 50 years of federal precedents. Today, the court belatedly explains that it declined to grant relief because of procedural complexities of the state's own invention. Because the court's failure to act rewards tactics designed to avoid judicial review and inflict significant harm on the applicants and on women seeking abortions in Texas, I dissent. September 1st, 2021. So from May to September, what a difference a couple of months makes. Lastly, we already have 2 lawsuits against a Texas doctor brought by private citizens. And this doctor has been a women's health provider in the state of Texas for 50 years. So these are his words that I wanted to leave you with, that he's talking about, how he views abortion. Again, he's been providing women's health for 50 years in the state of Texas. And so he's being sued by private citizens. Last time I checked, there were at least 2 lawsuits against him. And I think there are more. And at least one of the people bringing a lawsuit says that they're bringing a lawsuit in order to have the court get to the merits of the law, whether it's unconstitutional. And I also want you to note that, here he performed an abortion on the morning of September 6th. So, deliberately after the law is enacted, because he believes in what he's doing. And also, is like, well, if I'm going to get sued, I'm going to get sued. So with that, I will cede the floor to my colleagues. Thank you so much.
Wow. Thank you for that rundown, Professor McMurtry-Chubb. That was outstanding. This is such a critical case, and I'm so glad that you put it in the context that you did, including the context of judicial politics. It's something that we just can't ignore today or ever, and I'm so glad that you raised that issue. I do want to underscore for our participants just how revolutionary this approach is that Texas is adopting. If Texas's gambit ultimately succeeds at the Supreme Court, and that's what these lower court cases will now be testing, it would invite other state legislatures not only to outsource the enforcement of state laws that flatly deny a woman's right to an abortion, but it would invite states to outsource state laws that infringe on other individual rights as well. There's nothing in this ruling that would prohibit a New York or California or Illinois from adopting a law that outsources enforcement of another law to private citizens to sue anybody, for example, who owns a gun, right? A flat violation of the Second Amendment as the Supreme Court has interpreted it. And yet there would be nothing to prohibit a state from doing that, effectively trampling on Second Amendment rights, wholly eviscerating Second Amendment rights, just as the court's ruling wholly eviscerated the right to abortion in Texas, at least temporarily. We all hope the court goes back on this decision. It bodes well for nobody. Thank you again, Professor McMurtry-Chubb. Next up, we have our very own Professor Mundy talking about criminal procedure cases at the court. Professor Mundy, the floor is yours.
Thanks, Professor Schwinn. I'm going to be very brief for 2 reasons. First, I see 147 folks here, which is just so exciting. One of the things that I miss, I know we are sort of quasi in person, but I miss seeing you all, and I miss these events in person, and I really want to get to your questions. The second reason, and I'll start this way, when I started teaching criminal procedure 2 or 3 years ago, I was overwhelmed by the number of cases to discuss until I started thinking about my teaching as if I were playing in a Supreme Court cover band at family reunions and street festivals and weddings. And by that, I mean, the audience wants to hear the hits, right? The audience wants to hear Gideon and Miranda and Teri. The audience is not shouting for Arger Singer or wanting to hear something from Justice Breyer's experimental jazz trombone phase. We don't have any hits this year. We've got 3 Fourth Amendment cases, which speaks to the active docket in terms of Fourth, Fifth, and Sixth Amendment cases. But I don't hear any hits, and certainly not in comparison to some of the other cases that have been discussed today. So I'm going to be very brief in my comments, and I'm going to talk about two of the three cases. The first case is a case called Torres v. Madrid. I thought this case would be a relatively easy call for the Supreme Court. Roxanne Torres was in a parking lot with her car idling, was approached by two armed men. There's some discrepancy about whether Ms. Torres knew that the men were police officers. Fearing for her safety, she drove away. The officers, in turn, fearing for their safety, fired about a dozen shots into the back of Ms. Torres's vehicle, striking her at least twice and paralyzing her left side. Well, it turns out that the very intrepid Ms. Torres continued driving, actually stopped her vehicle, stole another car that happened, lots of cars idling in the Albuquerque area, as it turns out, stole another car and drove herself to the hospital. She later filed a civil suit against the police. And the question is whether being shot constitutes a Fourth Amendment seizure, which should tell you a little bit about where we are today in terms of Fourth Amendment jurisprudence. The Supreme Court ruled yes, but it was a much closer decision than I anticipated. And I think I speak for most people who follow the court. I thought, and most thought, that this case would neatly fit into the California v. Hodari D compartment, and that is, and I'll read you the brief holding from that case. The word seizure readily bears the meaning of laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. So it seemed clear that this was, in fact, a seizure following Hodari D. Well, it was a much tougher call than that, according to the court. So this was a 5-3 decision. Justice Barrett sat it out because she had just joined, or perhaps was not quite on the bench, perhaps didn't hear oral argument. So Justice Roberts sided with the justices that we would normally consider progressive or left-leaning, and wrote the majority opinion. Rather than simply following Hodari D, Justice Roberts, in typical Justice Roberts fashion, decided to cite a case from 1605, right? So the golden age of Fourth Amendment jurisprudence, 1605. The Countess of Rutland's case, in that case, the sergeants at Mace were executing a debt collection judgment against Isabel Holcroft, an English noblewoman. The sergeants touched Holcroft with, wait for it, a mace, not the spray, but like the medieval times thing. The majority explained that going back to 1605, getting hit with a mace constitutes a seizure. So certainly getting shot twice also constitutes a seizure. So what does this case mean for us? Number one, the language was much broader than I anticipated in terms of any touching constituting a seizure. It doesn't require bullets. And Justice Roberts was fairly intentional, I think, in terms of his language. So we hold that the application of physical force to the body of a person with intent to restrain is a seizure, even if the person does not submit and is not subdued. So physical force is going to be a question for the lower courts to interpret, but I think that we are going to have some interesting lower court cases about what constitutes physical force. Is it a tap on the shoulder with intent to restrain? Is it something more than that? Certainly it can be something less than being shot. So the rule was slightly more bright line, if you will, and a bit broader than I anticipated. The second piece is that in the context of an acknowledgement that police routinely use excessive force in situations that do not require that kind of force. I think this case is important because it provides Ms. Torres an opportunity to move forward with her civil claim. Now, much like Leon saves invalid warrants, qualified immunity and other hurdles may well save the police here, notwithstanding that this is a Fourth Amendment seizure. So it may be less important for that reason, but to the extent that it's at least a qualified referendum on excessive police force, I think it's an important case in that respect as well. I'm going to move very quickly to the second case, California v. Lang, kind of an important case for criminal procedure students to the extent that the definition of a Fourth Amendment search has been kind of a mess over the past several years, especially after the Jones case, where the late Justice Scalia kind of revived the trespass theory that we all thought was kind of a dead letter after Katz and the reasonable expectation of privacy test. Since that time, the court has had varied reasonings in search cases, but the court seems to continually reaffirm the sanctity of the home in terms of Fourth Amendment searches. So we saw this 5 or so years ago in Jardines involving a dog sniff. The court said this is a Fourth Amendment search because it occurred on the curtilage of a home. Maybe 2 years ago, we saw this in a case called Collins, where the Supreme Court said peering under a tarp to look at a motorcycle does not fall within the automobile exception, despite the mobility of this very fast motorcycle, because it occurred on the curtilage of the home. Here we get something similar where the court says, look, for certain misdemeanors, the court cannot rely on exigent circumstances, that is hot pursuit, to follow an individual into his garage, even if that individual is later, based upon the ensuing investigation, determined to be intoxicated. So in California v. Lang, the defendant was playing loud music and honking his horn, even though no one was in front of him. Now, I teach during the evenings at the law school, and that happens every class on State and Jackson, and I have not seen many police officers pulling over people for loud music and arbitrary horn honking. The officer in this case decided to activate his blue lights. Lang perhaps had the presence of mind to continue driving. He later claimed he did not see the blue lights and went not only into his driveway, but into his garage. Justice Kagan, writing for the majority, perhaps like many of you, I'm a big Justice Kagan fan for her writing, which is very sort of plain language and just very readable, for lack of a better description. As she noted, misdemeanors run the gamut of seriousness and can involve assault or domestic violence, but misdemeanors also cover a multitude of minor offenses like littering on a public beach or artificially coloring any live chicks or rabbits. I have no idea what that means, but apparently it's a misdemeanor, so don't do it. So the notion here is that not every misdemeanor can justify exigent circumstances vis-a-vis hot pursuit and allow police to enter a driveway or a garage. So again, we're seeing kind of in this uncertainty about what qualifies as a Fourth Amendment search, we're seeing another acknowledgement that what we do know is that the home takes primacy, is certainly different than other areas and property searched. So that is my quick review, and I appreciate all you being here, and I appreciate you, Professor Schwinn, for inviting me along for the ride.
Professor Mundy, what an outstanding presentation. Thank you so much. The Lang case, and I wonder if this may come up in Q&A later, but has potentially important implications for policing and race issues, where people of color are disproportionately subjected to police stops and searches based on claimed misdemeanors which gives police a tremendous amount of authority. And the Lang case is going to be a somewhat restriction on police's ability to pursue them in the wake of such misdemeanors. And so in that sense, maybe perhaps even a little bit of a progressive ruling this term from the court, but we'll see. Thank you again, Professor Mundy. That was outstanding. Next up, Professor Ricardo talking about a case that the court will hear this next term. Professor Ricardo, the floor is yours.
Thank you. Thank you, Steve. Thank you, Peggy, for helping organize all of the logistics for the presentation today. Thank you to my colleagues on the panel for your wonderful presentations. Really not only informative, but insightful. And thank you to the students who are in the Zoom call with us today. So I am going to be talking about the Mississippi abortion case, Dobbs v. Whole Women's Health. So as Professor Schwinn mentioned, we learned on just this past Monday that the Supreme Court will be hearing oral arguments in the Dobbs case on December 1st, 2001. And so this news comes, along with the news of what's happening in Texas and all of the litigation there. When I was working on an article I wrote, which is forthcoming at the end of this year in the Mitchell-Hamline Law Review, I was really focused on the Dobbs case. I didn't see the Texas case coming because of, and what Professor Schwinn will describe as the shadow docket in just a second. So it's a little bit as if the Texas case has kind of stolen a lot of the attention recently when it comes to abortion law and policy in the United States. But in December, we will be able to see in Dobbs an opportunity for us to sort of get a really well briefed and really, I'm sure, very interesting arguments. The arguments in the briefs are stunning. They're sort of very forthright. The Mississippi brief, the brief filed by Mississippi, has explicitly asked the court to overrule Roe and Casey in that many words. So I want to spend a little bit of time talking about how that happened by talking about some of the sort of pre-Roe and Roe history, and then circle back around to Dobbs. I'll also explain in the end to you why you're looking at a slide with the late Justice Ginsburg and two of those green circles. Okay, so I think the first thing to note is that in the United States, abortions weren't always illegal, weren't always regulated by the state, but in the years after the Civil War and by the early 1900s, all states around the nation had abortion restrictions. And so we go for another sort of 65 years until the court hears a case called Griswold v. Connecticut. Prior to this case, women and other people who could get pregnant in the United States had very few options in terms of controlling their own reproductivity and, sort of their futures because of that. But in 1965, in Griswold, the United States Supreme Court basically created a right for married women in their marriages to be able to access contraceptives, the pill, right? And they based this right on a reading of the fundamental right of privacy. So that's what we got in 1965. Excuse me. How do I get back? So that's 1965. In 1973, the court uses the same privacy rationale in Roe v. Wade, and comes up with this sort of very strict 3-trimester approach to the state regulation of abortion, right? Roe, we all know, declares that women and other pregnant people have the right to seek abortions, but also sort of balances that right with the rights of the states to intervene and to regulate in terms of their interests of a woman's health, of medical regulation, and any rights asserted on behalf of fetuses. So we've got this really sort of strict 3-trimester schedule. And it's also important to note that in all of the years after Roe, we've had a number of cases that have come up that have reduced Roe's potency, right? The strict scrutiny standard that was applied as against state regulations of abortions in Roe has been lowered. But it's really important to know that when it comes to the core holding of Roe, that is that states may not regulate abortion or restrict abortion access prior to fetal viability, that has been the core holding of Roe, and that has held consistent through all of the many years, the almost 50 years since Roe was decided in 1973. Roe and Casey are an important pair, and as I mentioned, the Mississippi brief specifically requests the United States Supreme Court to overrule these two cases. And in kind of stunning language, on the first page of the Mississippi brief, the state argues, and I quote, "This case is made hard only because Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania v. Casey hold that the Constitution protects a right to abortion." In other words, Mississippi recognizes that we have almost 50 years of unbroken Supreme Court precedents that say that pregnant people have a right to abortion and that states can't regulate pre-viability. Nevertheless, they specifically, or the state is specifically asking the court to overrule Roe v. Wade and Casey. So we know that the court is going to hear oral argument in December, but let me just give you a little bit of the factual background in terms of how we got to Dobbs. So in 2018, Mississippi passes a 15-week abortion ban. In other words, bans most abortions, almost all abortions after the 15-week mark, which is undeniably, and the state concedes, prior to viability. Immediately, the only abortion clinic in the state enjoins or sues to enjoin the law. There is a motion for temporary injunction that's issued by the district court, and later in an order, the Southern District awards summary judgment to the clinic, right? That ruling is affirmed in 2019 by the Fifth Circuit, and later, earlier this year, on petition to the Supreme Court, the court grants cert in this case. So that's how we get to Dobbs. One of the things that I think is important to note at this point, and just as a sort of recent sort of point of reference when we're talking about abortion law and policy in the United States, just yesterday, Marquette Law School, which is a Catholic law school, released the results of a poll that it conducted, in which, and this kind of reaffirms a lot of polling in other places, that a majority of Americans oppose overturning Roe. That is, I think it signals to me that in the 50 years since Roe, what we have is a lot of social controversy, certainly, but also a lot of coalescing around and supporting where the law currently stands, that pregnant people ought to have the right to seek abortion in order to control their own reproductive destiny. And I'm just going to end now with a plug to my forthcoming article, which puts the abortion law and policy question within the context of I compare essentially the United States to countries like Argentina, countries like Mexico, which are now sort of headed in the opposite direction, it appears, than the United States in terms of recognizing access to abortion as a human right that should be based in principles of constitutional equality and not so much on constitutional privacy. I will really end by explaining why Justice Ginsburg is on here. Obviously, we lost her last year, and as folks have noted, she's been replaced on the court by Justice Amy Coney Barrett. But she's here because my article talks about her very sort of important insights into the court's role in making decisions of a constitutional nature versus sort of thinking about things through the legislature or making reform through the legislature. I will end it there. Thanks very much.
Professor Ricardo, thank you so much for that outstanding presentation on such a critical and important case coming up to the Supreme Court very, very soon. And I love the picture of Justice Ginsburg. That's one of my favorite pictures of her. So thank you for sharing that with us. Such an important case, such an important turn at the Supreme Court. And as I'd mentioned, we've seen a lot of things happen at the Supreme Court this past year, and I think we're going to see many more things happen in the coming year. The replacement of Justice Amy Coney Barrett taking the place of Justice Ginsburg on the court, it's really hard to overstate exactly how important that is. By conventional ideological lines, the court is now divided 6-3, and we're starting to see that in the court's ordinary docket already in the cases that we heard about today, and we're likely to see that reflected in the court's rulings in cases next term as well, one of which I'll talk about here in a second, in addition to the Mississippi abortion case that Professor Ricardo mentioned. But before I do that, I want to talk about something that we don't often talk a lot about with the Supreme Court, and that's the so-called shadow docket of the Supreme Court. By the shadow docket, what we mean is Supreme Court rulings that come up on emergency motions to the Supreme Court to stop a lower court ruling. The way this works is, if the government is subject to a lower court ruling that it doesn't like, the government can file a motion at the Supreme Court to halt the lower court ruling and return to the status quo. Now, this doesn't really sound that interesting or important, but in the recent years, particularly during the Trump administration, we saw the government file an extraordinary number of these motions at the Supreme Court and have an extraordinary number of these motions granted. We've also seen the Supreme Court take really important action through these shadow docket rulings. Even though these are preliminary cases, the court has nevertheless ruled in a way that has telegraphed likely changes in the court's jurisprudence and actually made changes to the court's jurisprudence along the way. Professor McMurtry-Chubb talked about the court's latest endeavor to make new law through its shadow docket. But all through the summer and into the fall, we saw the court slowly chipping away at its free exercise jurisprudence in really important rulings involving COVID restrictions on gatherings. What was happening in this line of cases is that churches and other religious organizations were filing suit and seeking relief at the Supreme Court and getting relief through its shadow docket from government COVID restrictions in a way that was expanding free exercise rights that many of us have been predicting for a while, that Professor Wojcik talked a little bit about, and that the court may continue to expand in future rulings. And so the court's shadow docket is something that we really need to keep an eye on. The court's making tremendously important rulings on the shadow docket without full briefing, without full oral argument. without the participation of friends of the court or amicus briefs. And this is a troubling trend, in my view, that I think we need to keep our eye on and keep track of. There's one other case coming up soon that I think we ought to keep our eye on. It's a Second Amendment case. It deals with New York's concealed carry law, which requires individuals to show cause to get a concealed carry license in the state of New York. Plaintiffs have sued, arguing that that violates the Second Amendment, that anybody ought to be able to get a concealed carry license for any reason without having to show cause. The case is important for concealed carry, but it's important beyond that because the Supreme Court hasn't given us a firm test for how it's going to judge Second Amendment claims. The lower courts have come up with basically an intermediate scrutiny test. It's a little more complicated than that, but they've more or less coalesced around an intermediate scrutiny test for core Second Amendment claims. But the Supreme Court hasn't ruled on that yet. And so we expect to get a ruling from the Supreme Court on what exactly the Second Amendment means and what kind of test it's going to apply in these cases. So keep an eye on that Second Amendment case. It's an important one. Before we get to Q&A, I just want to say one more thing. We've heard a lot of references to different websites and sources online. I would urge you to check out some other sources as well. First off, I'm going to renew Professor Ricardo's call to check out her article. It is simply outstanding. You can get to it through the Social Science Research Network at ssrn.com and find Professor Ricardo's page on the Social Science Research Network. I urge you in strong terms to do that. And in fact, you can check out all of our SSRN pages while you're at it and see what we're up to. I would also urge you to take a look at SCOTUS blog, SCOTUS blog, as in Supreme Court of the United States blog, if you're not familiar with it. SCOTUS blog keeps the dockets of all of the cases that we've been talking about, the court's rulings, the lower court's rulings, commentary, and other resources that you might be interested in checking out. So with that, I think I'd like to open it up to questions. Now, I'm going to give us one caveat. We don't have the chat function again, and it's not entirely clear to me that we're going to be able to unmute you, but we're going to try. So if we can raise hands if you have any questions, and I'll call on you in turn, and we'll see if we can get you unmuted to share your question with the group.
And I just want to say, I keep thinking about Hugh Mundy's suggestion that we start a Supreme Court cover band. I think that's a great idea. The students will back me up on this, and next year we should just do the cover band version of this CLE.
I like it. I like it. While folks are thinking about questions, I have one that I'm intensely curious to hear my colleagues' thoughts about. Given what we've seen, friends, on the Supreme Court this past term and what we're likely to see in the future term, what are your thoughts about Supreme Court reform and the commission in the Biden administration that's examining Supreme Court reform? We've now had Justice Amy Coney Barrett come out publicly and Justice Breyer come out publicly saying, look, no need for reform. The court's not as political as you think it is, despite seemingly all evidence to the contrary. I'm curious to hear what your thoughts are about reforming the Supreme Court. Does anybody want to take that on?
Steve, I just want to note that Christine Drew has figured out that we can use the hand raise function to ask for questions.
Awesome. Thank you.
To answer your question, I think that the steam has gone out of that reform movement a little bit. I'd be really surprised if it goes forward, but I would like to see that, but I'd be surprised.
I agree. I think that the steam is out of it, but I think I think court reform is necessary. Mitch McConnell has been successful at thwarting additional appointments, and the court is out of balance, and that's not good for the long-term prospects of our democracy.
Participants may remember that some argue that the mere threat of court reform in the 1930s with FDR's court packing plan changed the trajectory of the court's jurisprudence in really important areas of the law. And one wonders whether the threat of reform might influence the current court to moderate its stance in some areas. Well, I guess time will tell, and we'll have to see.
Sorry, Steve, I wanted to just end with a comment there. I think that's absolutely right, the observation and the comparison point. And I think that that's why we see and have seen, not just recently, but since he's been Chief Justice, that Chief Justice Roberts has constantly, I think he bears the burden, he feels the burden of making sure that the court maintains its place in our democracy. And I think that's a very sort of a transparent sign about how politics impacts what happens at the court. In many, many cases, we see Chief Justice John Roberts, who was appointed by George Bush, take stances that probably aren't expected based on his background, but are really designed because he wants to maintain the integrity of the court, and he doesn't want to see it go down on his watch.
Professor Ricardo, what an insightful comment, and I share that 100%. He does, the conventional view is that he's an institutionalist, very concerned about the place of the Supreme Court and the integrity and reputation of the Supreme Court, and is working hard to uphold that. And we can see that in opinion after opinion, although there are some notable counterexamples as well. If we think about, for example, the Shelby County case that Professor Acevedo mentioned, or the parents involved case regarding school desegregation and school integration, pretty astonishing cases authored by Chief Justice Roberts that take extremely aggressive stances. It'll be interesting to see how he behaves and how his opinions read with the addition of Justice Amy Coney Barrett, now that there is a 6-3 balance on the court. Christine Drew. Oh, I'm sorry, Professor Wojcik, please.
I was just calling attention to what you're about to say.
Okay, thanks. Christine Drew, you have your hand up. I wonder, can you unmute yourself? Because I don't think that I can unmute you.
I can,
Awesome.
actually.
Awesome, thank you. Okay, go for it.
So I was actually going to ask, the panel's opinion about the potential expansion of the court. And then I realized that I had an additional question, which was what everybody's opinion of the recent discussion by Justice Breyer about his potential retirement and how that might impact and timing and everything like that. I'd be interested to hear everybody's opinion, especially if he does retire sooner rather than later, what the impact will be of us actually being able to get a new justice on the court, especially with the kind of the log jam sometimes we run into with Congress. So.
What a fantastic question. Thank you. Do we have thoughts on that? Christine, I can give you my own 2 cents on that. Progressives were urging Justice Ruth Bader Ginsburg to retire when President Obama could have appointed her replacement, and she declined to do that, and unfortunately passed away and left the bench during the Trump administration, when we saw then Senator McConnell push through Justice Amy Coney Barrett very, very quickly at sort of light speed in the waning days of the Trump administration, when most commentators thought that President Trump was going to lose the presidency. Now, that was an extraordinary move on McConnell's part, because you'll remember that he had previously declined to even consider the nomination of a justice to replace Justice Antonin Scalia, who died in February before the 2016 election. as President Obama was leaving office, on the theory that the Senate does not confirm a nominee in the last year of a president's presidency. The rule apparently is different for Republican presidents, and Senator McConnell did not hesitate to apply a different rule when confirming Justice Amy Coney Barrett. Now, does that have anything to do with Justice Breyer's decisions? One would think that on some level it must, but he has maintained again that that we overread the political nature of the court, that we ascribe too much politics to the Supreme Court, that it's not as political as we seem to think that it is, and that he's quite happy in his job and doesn't seem to be ready to go anytime soon. Does anybody else have any thoughts on that?
Justice Breyer is a recipient of the Scribes Lifetime Achievement Award. I'm the past president of Scribes, and we did a CLE program with him at the Law Library of Congress. Dean Dickerson did the interview of Justice Breyer. I think that if he's going to retire, it'll be at the end of this term. So we won't see anything in the middle of the term. Just if he's going to announce it, it'll be towards the end of the term. So we'll see a full year of him actively participating in the court.
Steve, I just wanted to go ahead. Briefly, in response to Chris's question also, I think that Professor Schwinn gave a really nice breakdown of some recent history to put that question in context. But I think my comment would be about the sort of precarity of our sort of justice system, right, and our democracy, that people are so concerned about the decision of one justice to retire. And I think that is it illustrates how important the judiciary is in our system of government, and also how volatile it could be depending on who is able to serve. And I don't think it should be all down to one person to make a decision.
Yes, right.
And I just wanted to add one more thought to this, that it's not just Breyer that the court watchers should be concerned with. They should also be thinking about Justice Sotomayor, because if you look on the opposite side, they're young justices, and they're going to be there for at least 30 years, an entire generation, and they're going to be shaping the law for this generation, for generations to come afterward. So I think to be honest, we need to be considering not just Breyer, but Sotomayor as well.
Both comments remind me that the lifetime appointments that we have in the United States, and the fact that things hinge on one or two justices at the Supreme Court, really is extraordinary by international standards. Constitutional courts and Supreme Courts around the world do not have the same kind of lifetime appointment that we have. They often rotate judges. They sit in panels, they do different kinds of things that we just have not even really seriously considered in the United States. But these are innovations that maybe we ought to be thinking about. And I'm hoping that something will come out of the Biden commission that moves in that direction. Michael, you have your hand up. Do you want to share your question with us?
Yes, thank you, Professor. I was wondering on that Texas abortion case where they're outsourcing enforcement. I was wondering, when those lawsuits come in from outside third parties, how would those people overcome any standing issues?
I think that's the point, right? That the statute has empowered individuals to bring lawsuits. So they're empowered to do so. Whether a judge wants to enforce it, that's the question, right? So now we have Dr. Braid, who has been sued multiple times, and he will be our test case. We'll see how it plays out. Then the reward is 10 grand. So, so basically, and we've seen on various, I've been listening to podcasts and interviews, and you just hear people who just want the money. They don't really care about the law. They're like, hey, I can make 10 grand just like anybody else. I'm going to sue, a doctor. I can do that. So it will be interesting to see, if the litigation goes forward, because as of September 20th, I think Dr. Braid had at least 2 lawsuits against him. So we'll see, exactly how this plays out.
Michael, part of what's in my view, so evil about the Texas system is that even if ultimately plaintiffs lack standing and these cases are kicked out for standing, the Texas statute prohibits fee shifting from plaintiffs who lose their case. So a doctor who a doctor who wins their case. So a doctor who wins their case, even on the standing ground, has potentially incurred a lot of legal fees simply arguing the standing issue, even if they are successful, which is a strong incentive not to violate the statute in the first place in order not to be in court, even if there is no standing, which means that you're not going to perform lawful abortions in the state. And as Professor McMurtry-Chubb, I think, well said, that's exactly the point. Just shut it down.
And I also wanted to say something about the stability of the court real quick, because we were talking about that before. And I think it really does speak to, what is the state of our country when you have whole generations of people who can enjoy one set of rights and then another generation that is precluded from enjoying those same rights. That's not a stable judiciary, right? So I think we need to really rethink, as Professor Schwinn said, how are we, tenuring people on the court, and should these terms be shorter than lifetime?
We have some questions lining up, and I want to respect everybody's time. So I'm going to take one more question, and then we'll wrap up. And I'm really sorry not to get to the other questioners, but maybe we can follow up on email. Jessica, do you want to go ahead, please?
Yeah, thank you, Professor Schwinn. So my question is also about the Texas abortion bill. So there has been some talk about Uber and Lyft, and like anyone that takes a woman to her abortion appointment, they can be sued. But then I've also been seeing people on LinkedIn and just other legal folks in the community talking about how that's not actually the case. Is there any comment on that? I mean, is this true? Can they be sued? I've seen that Uber and Lyft have also set up legal funds to approach the situation. So if you have any input on that, I'd love to hear about it.
Yeah, the statute is clear that if you assist in a woman getting we don't know, the interpretive frame for that is wide, right? What is assistance necessarily? So again, we're going to have to see the litigation play out to see how lawyers are arguing these cases. But yeah, certainly, if you give a ride to someone, if you give them money, any of that.
This is a case to watch as it moves forward. It really is a kind of live action constitutional law class on a lot of different levels, everything from the right to abortion, to the right to access the courts, to due process issues, to state legislative issues, federalism, just kind of includes a little bit of everything. And so I do urge participants to keep an eye on that case. I think it's a really, really important one about how our democracy works. I want to thank the panelists sincerely. This has just been a true joy and honor. We at some point hit almost as many as 150 participants. That's extraordinary. The summaries and the insight that you provided was just outstanding. I truly, truly appreciate it. I only wish that we could do this in person. I also want to thank Peggy Zemba for setting up the session, and Michael Huggins for all his wonderful assistance, Dean Spanbauer for joining and supporting us, and of course, all the participants. Your thoughtful questions and your active participation truly cannot thank you enough. So thank you to everyone. Enjoy the rest of your afternoon. Take care.